Welcome back, students. Uh, Students, in this lecture, we are going to learn what are the approaches to the universal jurisdiction and what is the rise of the universal jurisdiction, and what are those factors which decline the universal jurisdiction. Thereafter, we will discuss the one practical case, that is the Yerodia case. So here I'm going to demonstrate to you what are the approaches to the universal jurisdiction. So before I start, I'm going to share with you a slide. So approaches to the universal jurisdiction. So universal jurisdiction has often, at least since the International Court of Justice decision in the Yerodia case, if not before, been separated in two questionable subcategories. So these are what is often termed absolute or pure universal jurisdiction, which also known as the universal jurisdiction in absentia, and conditional jurisdiction, sometimes known as the universal jurisdiction with presence. Pure universal jurisdiction arises when a state seeks to assert jurisdiction over an international crime, usually by investigating it and or requesting extradition of the suspect. Even when the suspect is not present in the territory of the investigating state, the conditional universal jurisdiction, if a suspect is not present in the territory of the investigating state, and when a state start prosecuting that suspect, we call it universal jurisdiction in absentia. And thereafter, the conditional universal jurisdiction is a universal jurisdiction exercised when the suspect is already in the state asserting jurisdiction. The distinction has gathered considerable acceptance in academic literature. However, and although the matter is not entirely not beyond the controversy, the better view is probably that the distinction is non-existent at a conceptual level. Although a number of states have limited their use of universal jurisdiction to where a person is present on their territory, this can at least in part be explained on the basis of the adopting pure universal jurisdiction may show a lack of international courtesy. Where states have adopted such a limit, it appears that some of them have done so as a matter of practical prudence, or as the result of political pressure rather than as a matter of law. The resolution on the universal jurisdiction of the Institute de-droit international attempts to treat a middle path between the approaches by providing that apart from acts of investigation and a request for extradition, the exercise of the universal jurisdiction requires the presence of the alleged offender in the territory of the prosecuting state or other lawful form of the control over the alleged offender. However, the institution's resolution appears to mix question of jurisdiction and whether states are entitled under the human rights law to try people in absentia. It is also questionable whether adjudicative jurisdiction can be spilled up between the extradition and the trial in manner the institute suggests. In particular, as those asserting the distinction between absolute and conditional jurisdiction in Yerodia case, we are discussing an arrest warrant which was intended as a prosecutor to extradition. So it is this is the approach of the states under the universal jurisdiction of the states on the certain crimes, and thereafter why this jurisdictional issue rise in a cases. The possibility of the universal jurisdiction being exercised over the war crimes as a mooted during the Second World War A number of cases prosecuted after the Second World War could be justified, explained on the basis of the universal jurisdiction. The the United Nations War Crimes Commission took the view that the right to punish war crime is possessed by the any independent state whatsoever. Equally, those cases could be justified on the basis of the expanded passive personality jurisdiction which international law accepts for war crimes. In 1949, the Geneva Conventions provided a treaty-based analog to the universal jurisdiction in relation to their grave breaches provisions. In this connection, the Article 49 of the Geneva Convention, one to which the other three conventions have similar provisions, reads as under reads as follows: the wording of those conventions, that each high contracting party shall be under the obligation to search for persons alleged to have committed or to have ordered to committed such grave breaches, and shall bring such persons regardless of their nationality before its own courts, or handed them over to the another high contracting party. The grave breaches regime is often considered as the pragmatic case of universal jurisdiction, and in the practice is exceptionally similar to it. Still, it should be noted that the conventions speak of the grave breaches of their own provisions, given that the convention only applied to the conflict between the high contracting parties by their own terms, and grave breaches provisions only have inter partes effect as a matter of treaty law. Still, the fact that every state in the world has ratified the conventions makes this distinction of the form rather than substances. Mm, Probably the most famous exercise of universal jurisdiction was the Israeli prosecution of the Adolf Eichmann. Eichmann was abducted from the Argentine in 1960 by the Israeli agent security services Mossad, and which took towards the Jerusalem to be tried over there by the district court, which affirming Israeli right to prosecute him. Stated that by that court that the abhorrent crimes defined under this law are not crimes under Israeli law alone. These crimes, which struck at the whole of the mankind and shocked the conscience of the nations, are grave offenses against the law of nations itself. The principle which we have discussed earlier, the delicta juris gentium, which means the international law. So far from the international law negating or limiting the jurisdiction of the countries with respect to such crimes, international law is, in the absence of the international court, in need of the judicial and the legislative organs of every country to give effect to its criminal interdictions and to bring the criminals to trial. So the jurisdiction to try crimes under the international law is a universal. It might be noted that in spite of its comments about an international criminal court, which in the light of the principle of the complementarity now seem the district court opinion is a strong affirmation of the right to establish universal jurisdiction over the international crime. Israel did rely on the other basis of the jurisdiction, but its primary jurisdiction claim was universality. As the Supreme Court further explained, if in our judgment we have concentrated on the international and universal character of the crimes, one of the reasons for our so doing is that some of them were directed against the non-Jewish groups. So after this case, which is Eichmann, there was little evidence of any political will to engage in a universal jurisdiction prosecution until 1985, when Israel requested the extradition of the John Dimjan Juk from the United States. That is another case which I have already shared with you. Dam Jen Juk was suspected of being notorious camp guard in Terriblenka, known as the Ain Terrible, Ain the Terrible, the US agreed to extradite Dame Jen Juk, who stood trial in Israel, but was acquitted on the basis that although he was a guard at a Sobibor and Tuan Niki camps. The words students, the words are German or language or another, so that are very difficult to pronounce. If I commit any wrong pronunciation of those words, please forgive me. So I'm trying my best to pronounce those words, but I don't know the pronunciation of the German language. So these are the words Sabibur and Troambinki camps. These are the names of the camps where at the time of the extraditions and the brutalities of the German committed against the Jews. So these are the names of those camps. So he was not and the terrible. In this case, I have shared with you both cases, Dim Janjuk and Ichman cases, which actually define the jurisdiction, which is not, which we have already discussed, 4 jurisdictions, but these cases will give you demonstration upon the understanding of the universal jurisdiction, whether the person is not belonging to any country where the crime is not committed on their territory, but in spite of that, on the basis of universal jurisdiction, the state can claim any suspect from any country on the basis of the treaty, on the basis of the extradition, and can prosecute in their states. So further, as to another topic, next topic is the decline of the universal jurisdiction. The decline of the universal jurisdiction, although the 1993 statute gave rise to a member of the proceedings relating to the Rwanda, which did not upset the Rwandan government, the Belgian law proved to be a politically controversial. Proceedings were brought, though never completed, against, amongst the other, Ariel Sharon, Yasser Arafat, Fidel Castro, and Hashmi Rafsanjani. These proceedings all led to the political embarrassment for Belgium. These cases against the Abdullah Yardia and Nedom Belassi led to a challenge to the Belgium law in the International Court of Justice. So the decline of the universal jurisdiction, which the grave rise in the number of proceedings relating to the Rwanda proceedings, which occurred in 1993. So this case actually caused to the decline of the universal jurisdiction. But students, further, after a short break, we will come again and discuss the further case, which is very best case to understand the universal jurisdiction. So after a short break, I will give you a demonstration on that case.